I have been on this bench long enough to know that cruelty often enters a courtroom dressed as policy. It carries company memos, then speaks in neat little sentences about procedures, as if those words can bleach the human stain off what was done. That was what walked into my courtroom the morning Charles Benton stood before me. He was 67 years old, one day past what should have been his retirement celebration, wearing a pressed gray suit. His hands were large, scarred, and still, working hands, the kind that had lifted steel, fixed jammed belts, and fed a family for 42 years. At the defendant's table sat Owen Mercer, 39, operations director of Mercer Industrial Plastics, tailored Navy suit, and the expression of a man who had spent too long mistaking authority for wisdom. The case on paper looked technical: wrongful termination dispute, unpaid retirement bonus, withheld final benefits. But paper does not tell you what it means when a man works 4 decades for one company and is thrown out on his last day with a cardboard box and no handshake. I asked Mr. Benton to tell me what happened. He said he started at Mercer Industrial when he was 25 years old. Night shift maintenance, then machine repair, then senior floor mechanic. He trained 3 generations of younger workers, came in during snowstorms, stayed through heat waves, and missed birthdays, anniversaries, and once even his own anniversary dinner, because a molding line had gone down, and management said the shipment could not wait. He was not bitter telling me this. The company had announced 6 months earlier that Charles would retire on June 30th. There would be a ceremony, a plaque, a pension packet, and a retirement bonus of $25,000. His wife booked a family dinner. His daughter flew in from Ohio. His grandson made a card that said, "Grandpa finally gets Saturdays." Then on the morning of June 30th, 30 minutes before lunch, Owen Mercer called him into the office and handed him a termination letter. The stated reason was workplace misconduct. I asked what misconduct. Charles said the letter claimed he used aggressive language toward management and created a hostile environment during a staffing discussion the week before. He denied it. He said what actually happened was that he objected when Mercer announced the company would cut overtime for longtime floor workers while giving management performance bonuses. Charles said, "That's not leadership. That's theft with a spreadsheet." He admitted saying those words. Then he said Mercer told him maybe retirement had made him too comfortable and maybe he should leave before he embarrassed himself. 1 week later, on his final day, the company did exactly that. He was walked out in front of men he had trained. His badge was clipped. His retirement bonus disappeared. His accrued vacation payout was delayed. And the company sent a memo saying he had been separated for conduct reasons, making him look like a problem instead of a man who had given them the best years of his life. I turned to Owen Mercer. He sat back and said corporations are not charities, retirement is not immunity, and standards must apply equally. He said Charles Benton had become disruptive, resistant to modern management, and emotionally volatile. Then he made the mistake that told me who he was. He said, "Sentimentality doesn't belong in business, Judge." No, but decency does. I asked whether there had been any prior disciplinary actions in 42 years. No. Any written warnings? No. Any suspension? No. Any record at all suggesting aggression, harassment, or unstable behavior? No. Then I asked why the company waited until the very last day to act on supposedly serious misconduct. Mercer said timing was irrelevant. Timing is never irrelevant. Then Charles's attorney produced the evidence that changed the room. An internal email chain from Mercer Industrial's HR office. In one message, the finance director wrote that if Charles retired traditionally, the company would owe the full bonus, additional pension matching, and ceremonial recognition expenses. In reply, Owen Mercer wrote, "If we separate for conduct before close of business on the final date, we avoid the retirement package exposure." There it was. Not policy, planning, not discipline, cost cutting, not misconduct, a bookkeeping ambush. I had the email read aloud. Charles lowered his face and nodded once, as if hearing the cruelty in plain language somehow hurt more than being walked out had. Then I looked at Mercer and asked whether he wrote it. He said yes, but it was taken out of context. I asked what context could possibly improve. "We avoid the retirement package exposure." He had none. Then Charles said the sentence that finished the case for me. He said, "I could have taken another job 10 years ago, but I stayed because I thought loyalty was still worth something." That is what got me. Not because courts run on emotion, they don't, but because law without moral eyesight turns into accounting I ruled for the plaintiff in full: immediate payment of the $25,000 retirement bonus, full vacation payout with penalties, restoration of retirement status in company records, additional damages for reputational harm and economic distress. Then I ordered Mercer Industrial to issue a corrected internal notice stating Charles Benton had retired honorably after 42 years of service and that the prior misconduct basis was withdrawn. Owen Mercer objected immediately. Excessive, emotional, anti-business. I told him no. Pro-truth. Then I told him what I wanted preserved in the record. You did not fire a liability. You fired a ledger entry on 2 legs because your spreadsheet told you a decent goodbye cost too much. The room went silent. Charles did not cry. Men like him often don't in public, but his daughter did in the back row, and so did his wife. Before he left, I asked Charles one final question. What are you doing tomorrow? For the first time all morning, he smiled. Taking my grandson fishing, he said. I said, good. Court is adjourned.